one of the fundamental reasons why are we here? We're here because we are Americans, I believe, who have become frustrated with a system that appears to ignore what our founders put into place. There's some fundamental views of how you can look at how we got here. I'm going to show you the view of the war between the nationalists and the federalists. The issue at the very founding of this country is our citizenship. Does it come from Washington? Are we a nation of one people? Or are we a union of sovereign states? And that was always at war. And also, we're going to be getting into what is a state and what happened to everything. But in doing this, the real answer of how we get our country back and how we get back on a lawful foundation is for us to get back on a lawful foundation. We need to get into a lawful foundation with our Creator. We need revival. We need repentance. We need people who want the truth and nothing else. And the Lord Jesus Christ is the truth. God is the truth, the Spirit of truth. The Holy Spirit is the Spirit of truth, which will lead us into all truths. And Jesus said He's going to send the Holy Spirit after He leaves. And we're given warnings in 2 Thessalonians of what happens when the people cease having a love of the truth. It's talking about the coming of the lawless one. And it says the people will cease having a love of the truth, and the Lord will give them over to strong delusion to where they will believe a lie. And we're in a world today where we live in a world of relative truth and relative moralism. Relative truth means, well, that's true for you, but it's not really true for me. Like what I'm going to show you today. Some people say, well, John, that's true for you. It's just not true for us. Same thing happens with Hillary Clinton and her emails. Well, it might be not true for y'all that I'm doing something wrong, but it's true for us over here that I'm doing nothing wrong. Relative truth. And a lot of people will believe that with all their heart and soul, and they'll argue for it. And we have lots of people that will argue out of ignorance. They'll argue arrogantly out of ignorance. And we've got to be, what we're going to deal with is the difference between what politicians say and what politicians do. How many people believe politicians pretty much are upfront good guys and will tell you the truth straight up? How many believe that when they're telling you how they're going to frame legislation, like Obamacare, it's going, how it's going to, they're telling you up front the actuality of what it is. And the issue is we feel that, we know that, but that's been going on for a very, very long time. We live in a world of political correctness to where we're intimidated into belief systems, and we're all prone to it. The Lord tells us how we're supposed to act. It says, what does the Lord require of you, O man? To do justice, to love mercy, and walk humbly with your Lord. To do justice. How do you do justice in this world? When someone says, let's just pick the Confederate flag, it's an easy one to pick. That's a flag of hate. If I'm going to do what the Lord says and do justice, be just, I'm getting ready to give a condemnation or a justification for something. I've got to know the facts around it. In Proverbs, the Lord tells us that to justify the wicked and condemn the innocent both alike are an abomination. So if we start justifying the wicked, justifying the wicked, like their actions are good, we're not being just and we're committing abominations. It's our duty to get knowledge, to learn what happened. And we can either learn it from our school systems, we can learn it from the government. And how many people here know when the federal government got into public education, when those first debates were? March 1867, right along with Reconstruction. Exact same time. Because if they can get our children for a while, they can start teaching them all sorts of things that are okay. And they're doing it. And we're on a path as a people. I say we're on a path straight to our destruction. And there's a lot of sirens out there, and I'm using the Greek sirens, that are out there trying to sing us a song, tickle our ears, and keep us on this path. And I'm here to say, we need to lash ourselves to the mast. Don't listen to what's going on out there. It's our duty to read and understand what's going on. What we have in the news here lately, what is Ben Carson getting a lot of heat for? Saying that he would have a problem with a Muslim president. What does our foundation say? Patrick Henry, one of our founding fathers, says it cannot be emphasized too strongly or too often that this great nation was founded not by religionists but by Christians, not on religion but on the gospel of Jesus Christ. Adam said that the Constitution was designed for a holy, moral people. We don't have a holy, moral people anymore. And we have changed from a people under God, who we recognize God as our lawgiver, to a people who we want liberty and freedom regardless of God. In other words, it's a humanist, I want to do what I want to do. And that's reflected in our original state constitutions. These are right up here if anybody wants to read them. Constitution of North Carolina, 1776. No person who shall deny the being of God or the truth of the Protestant religion or the divine authority of either the Old or New Testaments, or who shall hold religious principles incompatible with the freedom and safety of the state, shall be capable of holding an office in the state. Constitution of South Carolina, that all persons in religious societies who acknowledge that there is one God and a future state of rewards and punishments, and that God is publicly to be worshipped, shall be freely tolerated. The Christian and Protestant religion shall be deemed and is hereby constituted and declared to be the established religion of the state. This is our foundation. Is this where we're at today? Is this where we're at today? No. Okay, something's changed. And hopefully by the end of this, you'll know what it is. What's a state? Let's just read it. A state, government, this word is used in various senses. In its most enlarged sense, it signifies a self-sufficient body of persons united together in one community for the defense of their rights and to do right and justice to foreigners. And do right and justice to foreigners. What we originally had was we did right and justice to foreigners. Now we've gone to the doctrine of equality, to where we treat everyone equally. We treat foreigners equally. We treat all religions equally. The difference that we have, one of the differences we have is the big difference between doing justice to people who are not a member of the body politic to treating them equally. The doctrine of equality is the doctrine that is destroying this country. And that comes out of the 14th Amendment, equal protection under the law. It says, in this sense, the state means the whole body of people united into one body politic. The state and the people of the state are equivalent expressions. The state is the people. The people are the state. Then they form a constitution. That's the constitution for the state, or the constitution for the people. Here's how this works. You have the people. They are the body politic. The people and the state government. The state government is the sovereignty is in the people, the sovereignty is in the body politic, and don't confuse the sovereignty is in the people with sovereignty is in the individual. There's a big group of people out there that say sovereignty, the sovereign citizen movement, where sovereignty resides in the individual. Sovereignty resides in the body of people, acting as one, forming their constitutions and laws that they consent to. The argument at the beginning of this nation was, are we creating a nation? What's this new constitution? A nation or a national government or a federal government? And if you read the Federalist Papers, that's what they're about. They're basically saying national in some aspects, federal in other aspects. I'm going to read from a book here, and I'm going to put some glasses on before I can do that. Again, what I'm going to go at is that the position that the Constitution and this argument over what this country is about. Now, this is a book, let me just tell you what this book is. This is The Origin and Growth of the American Constitution by Taylor, a documentary history. And this is published in 1911. Okay, so this is just about 40, 50 years after Reconstruction. And of course, this book likes the 14th Amendment and Reconstruction. He says the Constitution of the United States never reached its logical completion until after the adoption of the 14th Amendment. He says a better view is that prior to the adoption of the 14th Amendment, a man was a citizen of the United States only by virtue of his citizenship in one of the states composing the Union. And any such thing as federal or national citizenship, if anything such as a federal or national citizenship then existed at all, it was nothing more than a secondary and dependent relation. So national citizenship, they're saying, didn't exist before the 14th Amendment. It was really just kind of a secondary, your primary citizenship of your religion and everything else was in your state. But, turn a couple pages, and he's talking about the 14th Amendment, and he says, an able commentator on the 14th Amendment has said that it nationalized the whole sphere of civil authority. He says, the amendment therefore placed the essential rights of life, liberty, and property in the several states of the Union under the ultimate protection of the national government. The national citizenship thus created as a substantive and independent thing was placed in Section 1 under the protection of a new Magna Carta enforceable by the federal courts. Okay? This is 1911. Okay, they're talking about this new national citizenship that came after the 14th Amendment, or along with the 14th Amendment. But what did our founding fathers say about national citizenship? Where did our citizenship reside? Let's go to the Federalist Papers. Federalist number 39. It says the idea of a national government involves in it not only an authority over the individual citizens, but an indefinite supremacy over all persons and things so far as they are objects of lawful government. Among a people consolidated into one nation, this supremacy is completely vested in the national legislature. And he goes on and says, in this relation, then, the proposed government cannot be deemed a national one, since its jurisdiction extends to certain enumerated objects only. But what we're seeing here is, if we did have national government, or national citizenship, how much power would the federal government have over the individual citizen? If you nationalize citizenship, they would have an indefinite supremacy over all persons and things. This is what our founding fathers said would happen if it evolved into that. So the issue is, again, going back to state sovereignty, what are states? Federalist Papers say each state in ratifying the Constitution is considered as a sovereign body, independent of all others, and only to be bound by its own voluntary act. In this relation, then, the new Constitution will, if established, be a federal and not a national Constitution. These are big things our founding fathers were fighting for. The Articles of Confederation. Each state retains its sovereignty. This is the law graph. This is how this nation was set up. We recognize God as the supreme sovereign in His laws. He created man. He said, man, you can have your laws as long as they don't violate God. In this country, we have the state constitutions with state citizens. They form the federal government. In Article 1, as Congress has the power, what these little square boxes represent is a lawful delegation of authority, where Congress is acting within the law. What these circles represent are the unconstitutional acts that we see today that we rail against. Like they have no authority. That's not in the Constitution. My issue is they get all this authority to do this unconstitutional stuff through one act. Right there. And that's the Reconstruction Acts. This is the American Civil War. As long as we look at the American Civil War from a pretended moral position and instead look at it from a political position, politically, what came out of this war is the nationalization of citizenship. Lincoln is credited with preserving the Union. Did he preserve the Union? No. He created a nation of one. He was a nationalist. The Republican Party was a nationalist party. And our issue is if we can go after this one section, because we got lots of people that are fighting every one of these circles, spending hundreds of thousands of man-hours doing it. And if we can get people focused on the origin and foundation of this usurpation, and tenaciously go after it, we can get this country back with a very small group of people. This is the way the country operates now under Reconstruction. The federal government and all the usurpations reign supreme. God is to be eliminated. Federal government's over the states. This is an accurate display or portrayal of how we live today. These usurpations reign. They control us. And again, just look at the 14th Amendment, look at all these landmark arguments that are all, these landmark cases that are all, get their authority for the federal government to make the ruling, however they want to make it, from the 14th Amendment. Lawrence versus Texas, which struck down the sodomy laws, it violated the due process clause of the 14th Amendment of the Constitution. Roe versus Wade. State criminal abortion laws, like those involved here, they violate the due process clause of the 14th Amendment, which protects against state action against the right of privacy. Again, they get their power to make the ruling through the 14th Amendment. If the 14th Amendment wasn't there, they would not have jurisdiction over this case involving Texas, a citizen of Texas. But it doesn't involve a citizen of Texas, it involves a citizen of the United States. Stone versus Graham. This is the one that takes away the 10 Commandments, violation of the 14th Amendment. Abington School versus Shemp, same thing, violation of the Establishment Clause is applied to the states through the 14th Amendment. Wong Kim Ark, 1898. This is where we get the citizenship comes from birth. Again, there's an argument that a lot of people will make that the 14th Amendment was designed to give blacks civil rights and give them equal protection under the laws. If you read Andrew Johnson's veto of the Civil Rights Act and the 14th Amendment, or the Reconstruction Act, which passed the 14th Amendment, Andrew Johnson said that this act does not comprehend just the black. It comprehends the Chinese, the people called gypsies, Indians not taxed, because it says all persons born or naturalized. And you'll see that the Supreme Court in Wong Kim Ark supported Andrew Johnson's position. What Wong Kim Ark was about was that he was born to Chinese, he was born in the United States to Chinese citizens, went out of the country, tried to come back in, and they said, you can't come back in, you're Chinese. He said, 14th Amendment, I was born here, and he won the case. And that's that's the landmark case that set the anchor baby concept, that if you're born here, that comes from the 14th Amendment. What we're dealing with here is an unconstitutional act, I believe. I want to try to prove that. Let's just see what the Supreme Court, I think everyone knows this definition. An unconstitutional act is not a law, confers no rights, it imposes no duties, it affords no protection, it creates no office, it is in legal contemplation, it is inoperative as though it had never been passed. Therefore, an unconstitutional act purporting to create an office gives no validity to the acts of persons acting under color of its authority. This is a Tennessee case. So just remember that. An unconstitutional act creates nothing. It's a nullity in law. And what we want to do is look at a little bit of Mr. Lincoln and look into his character. And I don't want to spend a bunch of time because I don't have a lot of time, but I feel it's important to go over a couple of these. This is Abraham Lincoln's first inaugural address, April 4th. This is his handwriting. What they had done is they proposed an amendment that was going to make slavery permanent and irrevocable, and it was proposed 2 days before he was inaugurated. So that amendment, the proposed amendment, was 2 days before this speech is made. He says, I understand the proposed amendment to the Constitution has passed Congress to the effect that the federal government shall never interfere with the domestic institutions of the states, including that of persons held to service. To avoid misconstruction of what I have said, I depart from my purpose not to speak of particular amendments, so far as to say that holding such a provision now to be implied constitutional law, I have no objection to it being made express and irrevocable. So this is Abraham Lincoln on his inaugural saying, I have no problem with slavery, an amendment to the Constitution making slavery permanent and irrevocable. And he wages a war 6 weeks later. And we're told that he waged the war to free slaves. We have issues. July 4th, 1861, he held a special session of Congress of his reasoning for the war. And you're going to start seeing his nationalist views here. He says, they, the southern states, invented an ingenious sophism. The sophism itself is that any state of the Union may, consistently with the national constitution, and therefore lawfully and peacefully withdraw from the Union, secession, without the consent of the Union or any other state. And sophistry is a subtly deceptive reasoning. Let's go to the Declaration of Independence. Is the Declaration of Independence a secession document, the formal leaving of an association or union? It says, when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another and to assume among the powers of the earth the separate and equal separation. Our Declaration of Independence is a withdrawal of consent to be governed by another body. We had to fight for that one. This is Abraham Lincoln's speech in 1840 on Texas, when Texas was revolting from Mexico, wanting to become independent. This is his handwriting in a speech to Congress. He says, any people anywhere being inclined and having the power have the right to rise up and shake off the existing government and form a new one that suits them better. This is a most valuable, a most sacred right, a right which we hope and believe is to liberate the world. So Abraham Lincoln said, secession's a right, well, when it was Texas going from Mexico, but when it's the southern states trying to leave the American Union, he says it's a crime. Mr. Lincoln is not one of my big guys. Seceders insist that our Constitution admits of secession. What does the Constitution say? Article 7. The ratification of conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying. Let's talk about that. We were under the Articles of Confederation. They weren't working. In order to amend the Articles of Confederation, had to have unanimous consent. Rhode Island didn't show up to amend. It kind of rolled into what we call the Constitutional Convention. They said, and they proposed the U.S. Constitution. We were operating under the Articles of Confederation. Let's say this is the Articles. They proposed the Constitution. This says, the ratification of 9 of the 13 states shall be sufficient for the establishment of this new government. And who's it going to be between? The states ratifying. Did we as a body go from the Articles to the Constitution as one body? No. Individual secession through conventions. The ratification of the conventions of 9 states shall be sufficient. So that's how we seceded from the Articles of Confederation. We separated ourselves through Article 7 of the United States Constitution. And just to show you how that played out, here's how we did it under the Constitution. Delaware voted to go under the United States Constitution December 7th, 1787. Here's the first 9. Constitution goes into effect in 1788. Then you have Virginia and New York. February 4th, 1789, George Washington is elected president. March 4th, the United States government meets for the first time and George Washington is inaugurated. There's only 11 states in the United States of America at this time. 11 had seceded, had left 2 under the Articles of Confederation. They were North Carolina and Rhode Island. We were out of the Union for 8 months before we ratified it. We did not go from the Articles to the Constitution as a body. We seceded. It is in the Constitution. Lincoln says it's not there. Article 7 says the ratification of conventions of 9 states shall be sufficient for the establishment of the Constitution between states so ratifying. South Carolina held a convention December 20th, 1861, voted 169-0 to secede. All these states used the exact same procedure that was in the Constitution of the United States of America. Abraham Lincoln said it's not there. He says the express pledge by each of the original 13 in the Articles of Confederation that the Union shall be perpetual is most conclusive. He's absolutely right. The term perpetual was in the Articles of Confederation 5 times, so the Union shall be perpetual. But what did they do with the Articles of Confederation? They seceded from them. Which is more binding, the will of the people or the words on the page? The people have a right to alter or change. It's a right. And they proved it by going from the Articles to the Constitution. Is the word perpetual in the United States Constitution? No, because they knew it wasn't good wording. We just left one that said it was perpetual. We're just going to hop on over to this one. Lincoln said, and again, this is his defense for waging the war, July 4th, 1861, when he's calling for Congress to pass a bill for 75,000 troops to wage war. That's what this argument's for. He says, much is said about the sovereignty of the states, but the word is not in the national constitution, nor, as is believed, in any of the state constitutions. Okay, this is his nationalist view. There is no sovereignty in the states. We're a nation. Okay, well, let's just look at a little history. The Treaty of Paris settled the American Revolution. His Britannic Majesty transferred the title of the soil to all these states to be free, sovereign, and independent states. In the Articles of Confederation, it said each state retains its sovereignty, so it's in our history. The Federalist Papers said each state in ratifying the Constitution is considered as a sovereign body, independent of all others, and only to be bound by its own voluntary act. Abraham Lincoln, who has the Attorney General and all the powers of law at his hand, said it's not in any state constitution. Constitution of Massachusetts. For an oath to Massachusetts and a right ought to be a free, sovereign, independent state. It's in the Massachusetts Constitution 3 times about it being a sovereign state. Constitution of Vermont. The representatives so chosen, and they shall have all the powers necessary for the legislature of a free and sovereign state. This is one of the states that entered the American Union. Tennessee came in after the original 13. Article 32, contained within the charter limits of the states over which the people have a right of exercising sovereignty and right of soil. So Abraham Lincoln said, much is made about sovereignty, it's nowhere to be found. It's not in any of the state constitutions. Was it in state constitutions? Was it part of our history? Yes. The war is between the people who say we have a union of sovereign states and a nationalist. We're a nation of one. There is no sovereignty in the states. This is what the war is about. How strangely will the tools of a tyrant pervert the plain meaning of words. What's the definition of tyranny? I think John Locke said it good. I think it was John Locke who said that whereas usurpation is the exercise of power upon which another has a right, tyranny is the exercise of power which no one has a right. So to usurp something is to assume someone else's power. Tyranny is exercising a power that no one has a right to exercise. How many people have read The Object of the War? I think if anybody's ever listened to me, this is one of my standard things. The Object of the War, which is proposed by Andrew Johnson, senator from Tennessee. This is in July of 1861 on what's the object of the war. They got to tell the American people, what is this war about? And here it is, passed the Senate July 25th, 1861. Resolved that the present deplorable civil war has been forced upon the country by disunionists of the southern states, now in revolt against the constitutional government and in arms around the capital, that in this national emergency, Congress, banishing all feeling of passion or mere resentment, will recollect only its duty to the whole country. That this war is not prosecuted upon our part in any spirit of oppression, nor for any purpose of conquest, remember that, no purpose of conquest, or subjugation, nor for the purposes of overthrowing or interfering with the rights of the, or established institutions of the states, but to defend and maintain the supremacy of the Constitution and all laws made pursuant thereof, and to preserve the Union with all the dignity, equality, and rights of the several states unimpaired. Okay, so he says he's fighting to preserve states' rights. Preserve it. As soon as these objects are accomplished, the war ought to cease. Let's just break this down. The object of the war was not for conquest, subjugation, purpose of overthrowing, interfering with the rights of those states, or to overthrow or interfere with the established institutions of those states, slavery. Why could Lincoln say it was not for the purpose of overthrowing or interfering with slavery? 5 slave states stayed in the Union. It wasn't the slave states against the free states. Missouri, Kentucky, Maryland, and Delaware were Union states and slave states. West Virginia, which came into the Union in 1863, came in as a slave state into the Union, 1863. Now, with the provision that they get rid of slavery, but, and again, it's to preserve the Union with all the dignity, equality, and rights of the several states. And let's just look at this little timeline here. We just read The Object of the War, which, how many people have ever read that in a public education system? Probably haven't. Probably not being taught real well. Okay, the war ends 1865. December of 1865, the 11 previous Confederate states are considered back in the Union. Lincoln fought the war that they're not out of the Union. You are not a foreign country. You are merely states in rebellion to lawful authority. Of course, the Confederate states said, we're an independent sovereign nation that you're trying to conquer. Okay, Lincoln said you're never out. So December of 1865, the 11 previous Confederate states are considered back in the Union to the degree that they participate in amending the national constitution abolishing slavery. And here you can see North Carolina did it on December 4th, 1865. The amendment was ratified December 6th, 1865. Were these states considered member states of the Union in December of 1865? The answer is yes. Because they participated in the amending of the Constitution, Congress recognized their authority and ability to do that in 1865. Peace is declared by presidential proclamation April 2nd, 1866. So now you have peace declared. Why is it important that the president do it? He is the commander-in-chief of the armed forces. He's the one that knows what he's doing with the military. Okay, war's over. We're not doing anything. Peace is declared 1866. The 14th Amendment is proposed by the 39th Congress on June 13, 1866, and is rejected by all southern states except Tennessee. On March 2, 1867, the first Reconstruction Act is passed by Congress in times of peace over the President's veto, declaring that no legal governments exist in any of the former Confederate states except Tennessee, because Tennessee had ratified the 14th Amendment. The sole purpose and object of the Reconstruction Act was to pass the 14th Amendment. And I'm here to tell you the 14th Amendment was designed to nationalize citizenship. Abraham Lincoln called Governor John Ellis, this is at the very beginning of the war, he called for a regiment of troops from North Carolina because North Carolina had not seceded when Fort Sumter was fired on. And this is what Governor John Ellis wrote back to Abraham Lincoln. He says, "Your dispatch is received, and if genuine, which its extraordinary character leads me to doubt, I have to say in reply that I regard the levy of troops made by the administration for purpose of subjugating the states of the South as in violation of the Constitution and as a gross usurpation of power. I can be no party to this wicked violation of the laws of the country and to this war upon the liberties of a free people. You can get no troops from North Carolina." And we seceded shortly after that. A lot of people say all these southern states seceded so they can keep slavery. North Carolina seceded because we were going to stay in the Union. We already voted to stay in the Union. We're staying in the Union. We didn't feel the federal government had authority to wage war on states. Article 3, Section 3 of the Constitution says, treason against the United States shall consist only in levying war against them or in giving aid and comfort to the enemy. If Lincoln wages a war on states, he's committing an act of treason. I don't like Abraham Lincoln. I think he was a deceptive individual. Here's what Glenn Beck said on February 23, 2010. "The founders made it look easy. George Washington, Honest Abe, they were men of honor. There is no way anybody is going to risk their lives, their fortunes, or their sacred honor to follow a liar. Would have never worked. Restoring honor." I'm not sure Glenn Beck's figured it out yet. Now let's go to the Reconstruction Acts and read a little bit of the Reconstruction Acts. And you can see the very beginning. "Whereas no legal state governments or adequate protection for life or property now exist in any of the rebel states." They're declaring the state of North Carolina null and void. Now, what's the function of government? What's the relationship between a people and a government? It's called a reciprocal agreement. It's a relationship of protection and allegiance. Government is supposed to guarantee and protect the rights of the people. In return, the people are supposed to give allegiance and support to the government. It's the very first sentence of the original North Carolina Constitution. It's in all sorts of law that the function of government is to guarantee and protect rights, not to destroy members of its body. But let's just read Article 5, or Section 5 of it. Basically what the Reconstruction Act did was they wanted to pass the 14th Amendment. They didn't have enough northern states that would go for it. And again, the 14th Amendment I'm going to show you is to nationalize citizenship. They didn't have enough northern states to go for it. They couldn't get it. They needed all of the southern states in order to pass the 14th Amendment. Tennessee had adopted the 14th Amendment, so they had to get the other 10. So what Congress did was they annulled the states. They created new body politics. They said anyone that had participated in the war, you're not allowed to vote. You're disfranchised. Now, what we call that in law, it says that in the Constitution, there's a word called a bill of attainder. You can't have a bill of attainder. A bill of attainder is to declare a certain group of people, a definable group of people, guilty of a crime and punish them without a right to trial. And what this was, the Crown used it to declare people outlaws and punishable. These people have committed treason and they can be punished, wanted, dead or alive concept. No trial by jury. Lincoln is declaring, did any of these states have a right to face their accuser that they had actually committed a crime worthy of being kicked out of the American Union? Did North Carolina have a right to secede? Yeah. Did they commit a crime? No. Are they being punished for it? Yeah. Do they have a right to face their accusers? No. You're all just guilty. You don't have a state anymore. You can't vote. This is not for you anymore. It's for people who are loyal to this treasonous form of government we're creating. And it says this in Section 5, that when any people of one of the rebel states shall have formed a constitution or government in conformity with the Constitution of the United States, and when said state, by a vote of its legislature, elected under said Constitution, shall have adopted the amendment to the Constitution of the United States proposed by the 39th Congress, and known as Article 14, and when such article shall have become part of the Constitution of the United States, said state shall be declared entitled to representation in Congress. So what's this say? We're annulling you, North Carolina. Anyone who participated in the war, you can't vote. All blacks go. Now, a lot of people will say that the 14th Amendment was designed to give blacks civil rights. because of the black codes that were being imposed down there. And I'm going to tell you that the Reconstruction Acts are actually the largest black code ever passed. Why? Were there blacks in the northern states? Absolutely. What did the 14th Amendment do in the Civil Rights Act? Well, the 14th Amendment. 14th Amendment said that you only have black suffrage in these 10 states. Blacks do not vote in Tennessee. Blacks still cannot vote in New York, Ohio. Blacks could not vote in any of the northern states. And if you go back to the literature time, you'll start seeing they say, well, if we allow blacks to vote in the South, all the ones here will migrate southward. Again, it was designed to rid their state, to give enticement for these states, for the blacks in the northern states to go southward. They did not have a right to vote. That did not come until the 15th Amendment in 1870, 2 years later. And what the 14th Amendment did, and this legislation did, is it started pitting black against white. This is the creation of the friction, where the federal government said, you guys can't vote, you guys can't, and we're going to enforce it by the bayonet. Andrew Johnson vetoed the Reconstruction Acts, and he said this: another ground on which these Reconstruction Acts are attempted to be sustained is this. This is veto. That these 10 states are conquered territory. What was the object of the war not for? Conquest. Well, 2 years after the war was over, Congress decided to change the object of the war. Well, we think it was for conquest. They said it on the House floor and the Senate floor. Now, these 10 states are conquered territory, and the constitutional relation in which they stood as states toward the federal government prior to the rebellion has given place to a new relation, that their territory is a conquered country and their citizens a conquered people, and that in this new relation, Congress can govern them by military power. A title of conquest stands on clear ground. It's a new title acquired by war. This is a transfer of title of the state of North Carolina from the freemen of North Carolina to United States citizens residing here. It's a new title, conquest. They got it by the federal government conquering states. This is what Andrew Johnson said. There's not a foot of the land in any one of these 10 states which the United States holds by conquest. How would he know? He's the commander-in-chief of the armed forces. Congress had a resolution that said the object of war is not for any purpose of conquest. Did he have any authority to use the U.S. military to conquer states? No. He'd be violating the object of the war at the very beginning. It's not for any purpose of conquest. The U.S. military did not conquer these states. The Reconstruction Acts did. The Reconstruction Acts are a new war on the states. And of course, the Reconstruction Acts were passed over the President's veto because there was a supermajority in Congress, and we know what happens when you have a supermajority. And this is a statue on the grounds in Raleigh of the three presidents from North Carolina. Andrew Johnson's there, and it's got a picture of him holding the Constitution. Yeah, there's Andrew Johnson right there holding the Constitution. And right there he said, oh, he defended the Constitution. That's the one line they put under him to be remembered for. He defended the Constitution. What was the prize Lincoln and the radicals in Congress were willing to cause such devastation for? What was Andrew Johnson trying to preserve? What was the biggest prize that would give the federal government virtually unlimited power? And I'm here to say it's the 14th Amendment, because the issue was the 14th Amendment and Reconstruction Acts designed for the freed slaves, or were they designed to nationalize citizenship? That's what we've got to try to decide. Well, let's go to the writings of the people who were involved. James G. Blaine, he was one of the representatives in Congress. He wrote a book, 20 Years of Congress, 1861 to 1881. He loved Reconstruction. He wrote a book in his autobiography. Actually, this is his book, Discussions, where he has all of his political speeches. And he gave at a Republican mass meeting in Skowhegan, Maine, August 29, 1866. The Reconstruction Acts were proposed, the 14th Amendment was proposed in June of 1866. So this is a month later. And again, a lot of people say the purpose of the 14th Amendment was to give blacks civil rights. I say it's to nationalize citizenship. 1 month after they're proposed and sent to the American people, before they're even voted down by the southern states, he says this to his people. He says, and in making this extension of citizenship, we are not confining the breadth and scope of our efforts to the Negro. It is for the white man as well. We intend to make citizenship national. Okay? He also said this in his books, in his autobiography. He says, as the vicious theory of state rights had been constantly at enmity with the true spirit of nationality, the organic law of the Republic, which is the Constitution, should be so amended that no standing room for the heresy would be left. It was to get rid of state rights. Again, if you get rid of state citizenship, make everyone a citizen of Congress, there are no independent states. They're all composed of United States citizens rather than North Carolinians, South Carolinians, Virginians. They're all United States citizens. And to this day, a North Carolinian is not allowed to vote in North Carolina. Only a United States citizen residing in North Carolina. A direct cause by the Reconstruction Act. He also said the first section of the Constitutional Amendment, the 14th, which includes these invaluable provisions, is in fact a new charter of liberty to the citizens of the United States, is the utter destruction of the pestilent heresy of states' rights, which constantly menace the prosperity and even the existence of the Republic, and is the formal bestowment of nationality upon the wise federal system. Did our founding fathers intend for us to have national citizenship? No. Were the radical Republicans intending for us to have national citizenship? Yes. But he says all these new constitutions were ordained in the spirit of liberty, all prohibited the existence of any form of slavery, and all heartily recognized the supreme sovereignty of the national government. And again, we could go on with more. 14th Amendment said law conflicts and contradictions on the question, and the question was, where does your citizenship come from primarily, your state or the nation? He says the opening section of the 14th Amendment said law conflicts and contradictions on this question by a comprehensive declaration which defined national citizenship and gave to it precedence of the citizenship of a state. He quotes it, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. These pregnant words distinctly reverse the origin and character of American citizenship. Sound like something changed here? Something very fundamental changed? It reversed what we had. These pregnant words distinctly reverse the origin and character of American citizenship. Instead of a man being a citizen of the United States because he was a citizen of one of the states, he is now made a citizen of any state in which he might choose to reside. Again, the only people that can vote in North Carolina are United States citizens residing in North Carolina. They can go to any state they want and reside because they are antecedently a citizen of the United States. The consequences that flow from this radical change in the basis of citizenship are numerous and weighty. Let's just summarize 39th Federalist paper. The idea of a national government involves in it an authority over the individual citizens and an indefinite supremacy over all persons and things. This supremacy is completely vested in the national legislature. But he said that's not what the intention was. But now that's what we've got. The constitutionality of the Reconstruction Acts have been before the United States Supreme Court on 4 occasions. Every one has been met with obstruction of justice. Georgia v. Stanton, I'm not going to go over all the details of this. It says a bill to restrain the defendants who represent the executive authority of the government from carrying into execution certain acts of Congress, inasmuch as such execution would annul and totally abolish the existing state government of Georgia, is not within the jurisdiction of the court. Okay, so they refused to rule on it. They said, we're not touching that. They said because it did not deal with individual rights, it dealt with state rights that they had no authority over. But I really want to go over Ex parte McCardle. Ex parte McCardle, he was arrested. He was a Mississippi editor for writing editorials against the Reconstruction Act and this new constitutional convention in Mississippi. And who's supposed to defend the United States in an action against the United States government? The Attorney General. Okay? Well, Attorney General Stanberry had already written his opinion that the Reconstruction Acts were unconstitutional. That's what he gave Andrew Johnson for his veto. And so he had, in accordance with his conventions, answered that they were illegal and void and had advised the President not to approve them. This being his opinion, he could not, of course, take the other side of the question. Therefore, he had declined to argue it here. He had left it to be argued by those who believed in the doctrine. And he had given notice to General Grant, in consequence of which other counsel had been employed. So he says, I'm not arguing. I've already got an opinion that I think they're illegal. You need to go hire someone that believes it. Well, he ended up hiring a senator from the United States Senate who was a lawyer. Who defended McCardle? McCardle was defended by Jeremiah Black, former Chief Justice of the Pennsylvania Supreme Court, former Attorney General of the United States, former Secretary of State. Jeremiah Black said this in his oral arguments on this. He said a state election was going on which was superintended entirely by the Army, which by means of bayonets drove one set of voters to the polls and drove another away from them. The whole thing was accomplished by naked terrorism. And when an unarmed and peaceful man expressed his opposition to such proceedings through his own newspaper, he was told he should not do so and was ordered into custody. Which of the parties was guilty of intimidation? The accused or the accuser? It was said McCardle hindered Reconstruction. Congress desired that a certain constitution or form of government should be adopted and submitted to the people for their decision, or it was submitted to a portion only of the people of Mississippi. The act of Congress made a show for the expression of approbation or disapprobation, approval or disapproval. McCardle was not among those who were in favor of that Constitution. He was said to be hindering Reconstruction, the commission of a crime which there was a right to punish. No judge who had a clear comprehension of his duty would ask a man to plead to a tissue of absurdities like that. Yet if the trial of McCardle had gone on before a military board, he would not have had the slightest chance of escape, but would have been convicted. Military commissions never disappoint the expectations of those who order them. The federal government wanted to put him before a military commission, and now he's got before a civil authority, the U.S. Supreme Court. Well, General Gant hired Lyman Trumbull, senator from Illinois, to defend the Constitution or defend the constitutionality of Reconstruction. He never defended the constitutionality of Reconstruction. He basically defended saying that the federal government or the Supreme Court had no jurisdiction over the case. He says, I shall commence what I have to say by denying the jurisdiction of the Circuit Court under the Act of February 5th, 1867, to hear this cause. And if I establish that proposition, of course, this court cannot entertain jurisdiction of it. He goes on. He says, now I've gone substantially over the ground which I intend to occupy. The propositions which I have endeavored to maintain are first, this court has no jurisdiction of the case because the Act of February 5th, 1867 did not authorize the Circuit Court to take jurisdiction of it. Okay? Really, he had nothing. It looked like the Reconstruction Acts were going to be overturned. Well, what happened? Well, Mr. McCardle went back to the United States Senate to take away the jurisdiction of the Supreme Court in the McCardle case. So this is his, this is from the Congressional Globe. This is his debate to try to pass a law to amend the Act of February 1867, which would take away the Supreme Court's jurisdiction to make a ruling on the McCardle case, because he can't do it. And so he says, and he's going to be caught in a big lie here. I want you to see this big lie from Lyman Trumbull. He says, in my judgment, there is no great importance to be attached to it, this legislation that's going to take away the Supreme Court's jurisdiction. It is a bill of very little importance in my judgment, and I wish to say to the senator from Maryland that the Supreme Court has not decided that any case is pending before it under the Act of February 5th, 1867. No such decision has been made, nor do I believe any such decision would ever be made. He gave the oral arguments on it, and he's saying there's nothing over there. He says, now there is no such case that is pending in the Supreme Court, and there has been no such case pending in the Supreme Court. Well, Mr. Doolittle, James Doolittle from Wisconsin, said, Mr. President, my honorable friend from Illinois seems to think there's no importance in this measure, that it affects nothing and nobody, that there is no case pending in the Supreme Court which this act will affect, that it is a mistake and a delusion on our part to suppose there is any such case there under the law of 1867. Well, sir, if you be correct in this, why the great haste in pressing this bill? What does it mean? Sir, I apprehend that the honorable senator from Illinois is altogether mistaken in his view, which he now presents, that this is a very important measure, that there is a very important case pending in the Supreme Court under the act which it is now proposed to repeal. The honorable senator himself as counsel in that court, if I am correctly informed, with other counsel made a motion to dismiss a case pending in the Supreme Court or alleged to be pending under the act, and the court refused to dismiss it. We all know, the whole world knows, that this case of McCardle is pending in the Supreme Court. Brought up on appeal under the Act of 1867 from the Circuit Court of Mississippi, and that case has been argued by eminent counsel, and that it is pending. It is important because the case involves the constitutionality of the Reconstruction Acts. It involves the constitutionality of these acts which have been passed by Congress. If there be no such case before the court, why does the honorable senator desire to pass a bill to take away jurisdiction of a case which does not exist? Mr. President, the truth is, and we may as well look it square in the face, is because men know these acts will be decided unconstitutional. That is the reason why they desire to take away from the court the consideration of the question. And here's just a footnote from a book, Landmark Cases of the Supreme Court, on this. It's just a modern law book. It says, while the case was under advisement, Congress passed an act taking away the jurisdiction of the Supreme Court as defined by the Act of February 1867 in cases of habeas corpus, and the appeal was thereafter dismissed for want of jurisdiction. McCardle was thereupon discharged, and no further attempt has been made to test the constitutionality of the Reconstruction Acts. Okay, this is where I'm at. Since 1867, there's been no further test of the constitutionality of these acts which nationalize citizenship. It is my firm belief we have legal remedy if we have people willing to stand on what is true and just. We have two directions we can go in. We can say, this is water under the bridge. Nothing we can do about it. So therefore, here we are. We've just got to do the best we can in this situation. But the problem with that is we're always looking at the original intent of the Constitution, saying we've got those rights when they're really overthrown by this legislation. I say the remedy lies in, and I think Andrew Johnson actually said it pretty good. In his veto of the Reconstruction Act, he said, the remedy must come from the people themselves. They know what it is and how it is to be applied. With abiding confidence in their patriotism, wisdom, and integrity, I am still hopeful of the future, and that in the end, the rod of despotism will be broken and the arm heel of power lifted from the necks of the people and the principles of a violated Constitution preserved. Hear, hear. This is Andrew Johnson in his veto of the Reconstruction Acts. There's an issue of, well, did people really know all this? Was there any dissent? I'm just going to read, I've got a bunch of them, but I've only got a couple minutes. Democratic Party platforms of 1867. Ohio's Democratic Party platform. Because what you're going to find is this was a 100% party line. The Democrats were what we would consider Federalists. The Republicans are the original Nationalist Party. Okay? Democrats hate all this. They're fighting it tooth and nail. This is the Democratic State Convention assembled in Columbus on January 8th. These are the resolutions that they adopted of their position. He said, and this is number 2, that the states which lately attempted to secede are still states in the Union. They have been recognized as such by every department of the government, that being thus in the Union, they stand on an equal footing with their sister states with equal rights, that it was a thing unknown to the Constitution that Congress had power to deprive a state of reserved rights and reduce it to a territorial condition, that therefore the exclusion by Congress of all representation from 10 states, their proposed exclusion from the next presidential election, and reduction to territories are unconstitutional, revolutionary, and despotic measures destructive to the rights of those states and also every other state in the Union. Because if they can do it to one state, they can do it to all. They're setting the precedent. And a part of a plan to nullify the Constitution, virtually overthrow state governments, and erect despotism on their ruins and establish a tyrannical minority over a majority of the American people. 1867. This is the Democratic Party platform, state of Ohio. I've got them from Connecticut. The highlighted ones are ones I would normally read. I've got them from Maine, Maryland, Massachusetts, New Hampshire, all northern states. I only picked northern states. You know what the southern states had to say about it. These are the northern state conventions saying this is unconstitutional, despotic, an overthrow of the Constitution, a revolutionary. And have they been tested in the United States Supreme Court? I don't have time to go over my position. I think most people in here already know my position, which is the reason we don't have lawful government is no one's participating in it. Everyone wants to get remedy in the usurpation. We have a right to pick up the Constitution that the Reconstruction Act said was null and void. It was never changed by the consent of the people of North Carolina. We have a right to repopulate it, reestablish it, and then stand in defense of it, even if we're a minority. There's people who say we don't have a majority. American Revolution didn't have a majority, 3% of the American people. I say that we can do this with 1/2% if we can get a tireless minority intent on setting brush fires in the minds of people to get this country back with the truth of what happened. We can get it back. Why 1/2%? What's the population of North Carolina? Anybody know? How many? 3 million. What's 1%? 30,000. What's 1/2 of that? 15,000. You think if we had 15,000 people standing at a courthouse demanding the state they prove their lawfulness? How did gay rights get where it's at? How many people do they have going and standing in the streets? Immigration rights. How many people do they have standing in the streets? If we had 15,000 in North Carolina, 1/2%, 1/2% in South Carolina, New York, Colorado, Tennessee, standing in the streets, prove your lawfulness, prove you had a right to wage the war, prove you had a right. Because what you're going to find is, in all the legal documents, they're going to say that the issue of secession and nullification were settled by the Civil War. Excuse me. The Constitution says you cannot have an ex post facto law. The war cannot resolve anything. Is war what's supposed to set the laws of this country, or amending the Constitution by the consent of the people? By the sheer fact that it's commonly stated in all the literature that the war settled these legal issues shows it was done not by the consent of the people, not through the rightful action of the Constitution, an amending process, and people deciding what they want, but by Abraham Lincoln and the 39th Congress to overthrow everything this nation was founded on. I don't participate in that system. I appreciate your time. I look forward to listening to the other speakers. We're going to have a round table on this at 5 with all the speakers. At 4, write your questions down that you might have, that you want to have, and get them passed up. And I am done. Thank you for your time.